How does a Texas divorce work? Well, this is the third of a series of videos that I'm doing. Today, we're going to talk about how the children's portion of the divorce works. Now, if you don't have any children involved in your life, then this particular video doesn't have anything to do with your divorce. But the first question is, what children are we talking about? We're talking about children of the marriage. So if the only kids in your household are your children and not your spouse's, or they're your spouse's children and not yours, or sometimes you have your children there and sometimes you have your spouse's children there, but you do not have any children in common, then again, these next two sections that we're going to talk about of a Texas divorce don't apply in your case. But if you do have a child of the marriage, then these sections do apply, because if you are going to go through a divorce, you are required to couple with it a suit affecting parent-child relationship. You'll see it abbreviated as all capitals SAPCR, suit affecting parent-child relationship. If you are going through a divorce in the state of Texas and you have children of the marriage, you actually have at least two lawsuits that are coupled together. If you look at what we call the style of the case, the top section of any of the pleadings in the case, what you'll see is it says in the matter of the marriage of, and then it will have the two spouses' names. And then if there are children of the marriage, it will also say, and in the interest of, and then it'll list the children's names. So that is showing you, that is telling you that it's really two different cases joined together. So what are the differences? Well, the primary difference is this. When you're dealing with all those property issues, you're dealing with a rule called res judicata, meaning you only get one bite at the apple. Once the property is divided, it's divided. Once the debt is assigned, it's assigned. Once all of those things are done in the case, it falls under the general rule of lawsuits. Once you are done with it, then you're done with it. You're not going to go back and revisit those issues. There are ways you can undo a case. There are appeals, motions for new trial, things like that can happen. There's even something called a bill of review that can happen quite a while after a case seems to be resolved. But generally speaking, when it comes to property, you're dealing with res judicata. Once it's been decided, it's been decided. With children and the children's portion of the case, that's not the rule. Everything that gets decided in the children's portion can be revisited. It can be modified later. And so you can go back to court over and over and over with respect to all of these children's provisions that we're going to talk about today, because res judicata simply doesn't apply to that in the same way. So let's look at what children we're talking about. Well, again, children of the marriage. So it needs to be children in common between the two spouses. And then what is a child? Well, generally speaking, under the Texas Family Code, what you're talking about is children of the marriage that are under the age of 18 and not yet out of high school. So if they have turned 18 but they've not graduated high school, they're still considered a child for certain purposes, which will be support purposes but not custody purposes. Once they turn 18, theoretically, the custody rules don't apply anymore. Or if they've graduated high school but they haven't turned 18, then both of the sections apply. The support and the custody applies. One thing to remember is that adopted children are just the same as biological children. So if you have adopted your stepchildren, if your spouse has adopted your children, then it is just as though they're biological between the two of you, and then they would be considered children of the marriage. So what gets decided with respect to these children? Well, the first thing to look at is the titles, what we call conservatorship. If you actually look in the order once it's done, you'll see that the word custody, if used at all, is only used in a couple of warnings and maybe one other spot. So conservatorship is the actual term in Texas that we use for the titles that people have. If you go back to the olden days, the titles told you almost everything. Back in those days, when people went through a divorce or just a custody case, if they weren't married, then the titles were what decided things, at least for the most part. One person would be named the managing conservator, and the other person would be named the possessory conservator. So I remember when I was learning those terms, I thought they were somewhat confusing because to me, possessory sounds like you're the person in possession of the children, but that's not really what it means. The managing conservator is considered the more dominant title. And so what has happened in the last few decades is they've changed that. It used to be one was named managing, one was named possessory. The one that was named managing got the children. The managing conservator was the one in the olden days who had the children most of the time, who got to make all the decisions that were the important decisions with respect to the children, who got the child support and all of that. The possessory conservator was the one that had the possession schedule, meaning that person only had the right to have possession of the children at certain times. So now what they've done is they've changed that. The titles are still there, but now the presumption is that both people are going to be named joint managing conservators. And that can be confusing because a lot of people think that what that means is, oh, we're equal. I'm named a joint managing conservator and so is my spouse, so we're equal. Well, it's really just a title. What matters are the rights and duties. The rights and duties that come under the titles are what really matter. And those are broken up into a lot of different rights and duties. So the first thing you come to typically when you're looking at one of these orders in Texas is the rights and duties that both people have all the time. So unless there's something really hinky going on in the case, you normally have two parents who both have the right to attend school activities, who both have the right to look in school records, who both have the right to access to medical records and things like that. Those are not the kind of thing that people typically fight over. And then you have some rights that each person has while they have possession of the children. So a simple example of that would be the right to get medical treatment for the child of a non-invasive type. So if the child gets a cold or the flu or something and needs to go in and just get some antibiotics, then that's something that either person can do while they have possession of the children. But the rights and duties that people fight over and what really matters are the next ones you come to. And the first of those is the right to be primary. You hear that term used all the time in Texas custody cases. Who's going to be primary? And that's because that is the modern version of what that old managing conservatorship used to be. Generally speaking, if you are the joint managing conservator and you are named as the primary, then that means that you get all of the goodies throughout the rest of the order, meaning you're the one that receives the child support. You're the one that has the more dominant side of the possession schedule. You're the one that has the more dominant rights when we're looking at some of these other rights. So what is that primary? Well, if you actually look at it in a Texas custody order, what you'll see is that it says one party or the other has the exclusive right to designate the primary residence of the child or the children. Normally speaking, the person who is named as primary is the one that people look at and say, oh, that's the one the child is living with, because that's the one typically that the child is with more often. So this right of primary can come with a geographic restriction or without a geographic restriction. Geographic restriction is also known as domicile restriction, is also known as residency restriction. The court does not have the power to order the parents to live anywhere. That's unconstitutional. So the court can't order either parent to live in any particular place or within any geographic boundary, but the court can order the primary residence of the child be within a certain geographic boundary. And that's what a residency restriction is. That's what a geographic restriction is. If somebody is named as the primary and there is a geographic restriction attached to it, then what the court is saying is you have the right to establish the primary residence of the child, but it has to be within a certain geographic area. So what is that geographic area? Well, for years, what you would see would be a lot of courts would name a particular county and then the counties contiguous to that. It's the primary county there in the middle and then the counties that touch it all the way around. But over the years, some courts have looked at that and said, well, in certain areas, you can have counties that are so big that even though they're touching, if one person lives all the way on one end of one and the other person's allowed to move all the way to the other end of the other on the opposite side of a large metropolitan area, it can be a real challenge. It can be a real mess and a real hardship on the children. And so courts sometimes will tighten that up and they will say that the geographic restriction is just to one particular county. You can have geographic restrictions as small as to a school district. You can have them a certain number of miles from a particular point, whether that's the residence that the person is in at the time the order is entered or any other place that you want to look at. You can have a geographic restriction to the state of Texas. You can have a geographic restriction to the United States of America. You can have any geographic restriction that you can dream up, and it can be a part of the order. And what gets really interesting is that in Texas, you are allowed to have a jury trial on certain issues, not on most issues, but on certain issues. And the issues when it comes to children that you can have a jury on are the issues of the titles. So are you a managing conservator? Are you a possessory conservator? Are there joint managing conservators? That can be one jury question. The jury can also be asked to decide on who is primary, which parent is named as the primary, the one with the right to establish the primary residence. You can also ask the jury to decide whether or not there is a geographic restriction, and you can ask the jury to decide what that geographic restriction is, assuming that they decide that there should be a geographic restriction. So again, geographic restrictions are not automatic. If one party or the other is named primary, then the next question is, will there be a geographic restriction? And then if the answer to that is yes, then the question becomes, what will that geographic restriction be? And then the next question would be, can it be lifted? And if so, under what circumstances? The next thing to know about the issue of primary, and is one parent named primary, is that if the parents agree, they can decide in a settlement that they don't want either parent named as the primary. That's okay. Now, if the parents settle and if they agree, nobody has to be named primary. And that's sometimes a popular way to settle a case, or at least to attempt to settle a case. But if the parents do not agree, if you go to trial and you put it to the judge, then the judge has to pick one of the parents to be primary. The judge is not allowed to, at the end of the case, say that there won't be a primary. Now, that's always kind of an interesting issue when you say the judge can't do this or the judge must do that, because I've been involved in a case that went all the way to trial, and at the end of the case, the judge said, I'm not going to name a primary. So it is interesting when you look at it and consider what the court must do compared with what courts actually do. The next part of the case are the rights that people really care about. We refer to those as med, head, and ed. So it's the right to make the medical decisions for the child, the right to make the educational decisions for the child, the right to make psychological and psychiatric decisions for the child. Those are very important. Those can all be very life-changing things. All of these rights can be awarded exclusively to one person or the other, or they can be awarded jointly, meaning the two parties have to agree, or they can be awarded independently, meaning that mom can go and do something when mom wants to, and then dad can go and do the exact opposite when dad wants to. Or sometimes what you'll see is that they will be awarded exclusively, but after consultation. And that one's gotten to be popular in recent years. But you have to really consider what that means and what the court is going to do about it, if anything, if that consultation doesn't take place. So sometimes that is used as kind of a sweetener to get somebody, maybe in a mediation or a negotiation, to agree to let you have an exclusive right, because you tell them, well, we'll put in there that it's only after consultation. But then that begs the question, what is the consultation? How meaningful is the consultation? And what if we don't agree when we get to the end of it? But really the problem is there is no perfect solution to any of this, because if the rights are awarded jointly, you can run into a real stalemate where the parties simply won't agree. And now you're back in court just arguing over that one issue. And I've had cases like that. If they're awarded independently, you can literally have a situation where mom goes and signs a child up in one school, and then dad withdraws the child from that school and goes and enrolls the child in the other school, and then mom goes and gets the child out of that school and takes the child back to the first school and re-enrolls them there. So that can create a mess. And then, like we've talked about, the issue of the consultation can, to a large extent, be meaningless. So the next thing that you generally see is the possession schedule. And the possession schedule, again, if the parties agree, it can be whatever they want. If they don't agree, it's going to be left to the court. If you leave it to the court, generally speaking, what you can expect is some version of a standard possession schedule. So what is the standard possession schedule? Also known as the standard possession order. That is actually a law in the Texas Family Code where the legislature came out with this schedule that said, okay, this is the standard possession schedule. This is something that we're going to put into the law as presumed to be reasonable. So courts can rely on it. They can say, okay, I'm just going to order that mom is going to be primary and mom's going to get these exclusive rights and dad's going to get a standard possession schedule. So what is that? Well, that's the thing that most people are used to. It looks kind of like the every other weekend sort of thing. It's not technically every other weekend because there are some fifth weekends that come up and then there are holidays that interrupt it and things like that. In the olden days, you used to see the midweek on a Wednesday. They changed it a few years ago to where the midweek was on a Thursday. But you have that midweek time. Some people call it visitation. Some people call it possession, whichever. It's just time that the non-primary parent has the right to have possession of the children. And there's something that they invented several years ago called the extended or expanded standard possession schedule. If you are the non-primary parent, you end up with some extra time because instead of having to just go get the kids on Thursday night and take them to dinner for a couple hours and bring them back to the other parent's house, you get to keep them overnight. You get to pick them up from school if you want to and keep them overnight and then take them back to school the next day. And then on the weekends that are your weekends, instead of having to take them back to the other parent's house on a Sunday night, you get to keep them until the next morning, typically Monday morning, or if Monday's a holiday, till Tuesday morning. That's that extended or expanded possession schedule, which is an improvement over the regular standard possession schedule or standard possession order. But there are also a billion other possession schedules that you can have. You can have anything that you can dream up. If you and the other parent settle, then anything you can come up with, you can stick in the order as the possession schedule. And I can almost guarantee you that the judge will approve it. The judge is almost certainly not going to go through your order and analyze the possession schedule and see whether or not the judge likes it. Generally speaking, if you and the other parent can agree, then the possession schedule can be whatever you want it to be. So what do people want? Oftentimes people want a 50-50 possession schedule, and then the question becomes, well, how are we going to divide the 50-50? There are some particular schedules out there. One is called the 2-2-5-5, and one is called the 2-3-2-3, and those lay out just a certain kind of tricky little schedule to talk through. But if you look at it on paper, it makes sense. A lot of times people talk about a week on, week off. You can do a week on, week off. You can do a month on, month off. Again, whatever you settle on, you can put in there. But you do need to be careful because once you deviate from the standard possession schedule, you can get into some real interesting issues of enforceability and you can create some gaps. The legislature gets criticized routinely, but if there's one thing the legislature got right, it's when they designed the standard possession schedule and the extended or expanded standard possession schedule. They created a system where there really aren't any gaps. There's no point in time at which you just can't figure out where the child is supposed to be. And they did a really good job of that. So once you start tinkering with it, then you can create some situations where either both parents can claim the right to have the child or nobody can show that they're supposed to have the child at a particular time. So you need to be careful. You can have a great many other things as a part of all of the possession. You can have certain schedules for kids of certain ages. You can have split schedules based on various things like maybe the kids' activities. You often want to have built in something about what's going to happen if the parents do move a particular distance apart. So you can have a separate contingent schedule at that point. A lot of times it's a good idea to have long distance travel provisions. Two really popular provisions that are out there are electronic communications provisions because nothing is more upsetting if you've gone through a divorce or a split and now the other person is not allowing you to communicate with your child electronically, not allowing you to talk to them on the phone, to text with them, to FaceTime with them, all of those kind of things. So that can be put in the order. There's something called the right of first refusal And that's something that a lot of people like, or they think they like. But the problem with the right of first refusal can be that it's difficult to write it in such a way that it really accomplishes what you want. So you have to think that through, because are you really trying to create a situation where every time your child is going to go to a birthday party on a Saturday afternoon for 3 or 4 hours, the other parent has the right to possession of the child? That's normally not what people want. But if you're not careful about how you write those things up, you can end up with those kinds of situations. And I can tell you from my experience, Texas judges do not favor right of first refusal. You can get that in your order if you agree, but my experience is if you actually leave it to a judge is almost certainly not going to put a right of first refusal in the order. And the reason for that is simple. Judges don't want to see you again. It's not that they don't like you. It's that they're very, very busy. And the last thing they need is to create a situation in which people are coming back into their court continuously arguing about things. And the right of first refusal is one of those things that can easily be argued about from now until the end of time. So that's pretty much all of the custody parts that I want to cover in this video. Thanks.